Shante, short, QASHONTAESHORT.
Before we even step into this courtroom, let me set the stage for you. What you're about to witness isn't just a messy breakup dispute. It's a full-blown legal meltdown over a single date, one date, and somehow that turns into a $10,000 lawsuit for intentional infliction of emotional distress. But here's the twist. The plaintiff files in the wrong court, and when the judge calmly explains jurisdiction, instead of listening, she doubles down, then triples down, then argues about what perjury means with a judge. This case is everything. Misplaced confidence, legal misunderstandings, escalating attitude, and a judge who slowly realizes he's not dealing with someone confused. He's dealing with someone convinced she's right. Watch closely, because this isn't just about a bad date. It's about what happens when ego collides with procedure. And trust me, it only gets wild.
I'm looking here, what is it? Intentional infliction of emotional distress?
Yes.
Is that the claim here?
Yes,
Okay.
It is.
That's not something that's really justiciable in district court.
I'm sorry, I can't hear you.
I said that's not something that's justiciable in district court. That has to be brought in circuit court.
So you said it's not permissible in district court. It has to be taken to circuit court?
That's an equitable action, yes. Mm-hmm.
I thought only criminal offenses. Oh, well, I guess it would be considered. I don't know if it's criminal or however you want to consider it. But
right here is where the first major crack appears in the foundation of this case. The judge is calmly explaining something basic but crucial. Jurisdiction, intentional infliction of emotional distress, is a civil claim that belongs in circuit court, not district court. That's not an opinion. That's procedural law. And when you file in the wrong court, everything that follows starts off unstable. What's fascinating is that she's not new to filing lawsuits. The record mentions prior claims against companies and even multiple police departments. So this isn't someone unfamiliar with the system. Yet here we are, arguing about which court handles what. This moment sets the tone for everything that follows. Confidence without comprehension. And in a courtroom, that combination rarely...
To be honest with you, sir, I thought this was just going to be thrown out. We had a date, one date, and nothing else after that. And now I'm being sued for $10,000.
Pause on that number for a second. $10,000 for one date. That's not just a breakup dispute. That's a calculated claim of measurable emotional damage. And in civil court, damages have to be supported. You need evidence. You need conduct that meets legal standards for extreme and outrageous behavior. Not just disappointment. Not just regret. Not just it didn't work out. Courts don't award money because someone feels slighted. They award damages when legal thresholds are crossed. And so far, we haven't heard anything remotely close to that standard. Meanwhile, the defendant sounds stunned, like someone who thought the worst outcome of a bad date was an awkward goodbye. Instead, he's learning civil procedure and...
A motion to ask for that.
I will do that. I really didn't know what to expect. This is all new to me. I've never been sued before. I've never, gotten in any trouble. This was just, I don't know. But if that's the process I have to take, then that's what I'll do.
There was also a perjury on there as well. He stated, I can't remember what he stated right now because I don't have it, the document in front of
me. Short, perjury is a criminal charge.
Okay, there were two different charges.
This is where things escalate dramatically. Perjury is not a casual accusation. It's a felony. It requires a knowingly false statement made under oath during a legal proceeding, not a disagreement, not conflicting stories, not he lied in a text message. Under oath, in court, that distinction matters enormously. What we're seeing here is a misunderstanding of legal terminology, and terminology is everything in litigation. Words aren't vibes, they're definitions. The judge is trying to explain that perjury isn't something you tack on, because you think someone's being dishonest. It's a criminal charge that requires prosecutorial action, and instead of recalibrating, she pushes forward. That resistance, that's going to define
I guess that could be considered a criminal offense.
Ma'am, I'm not going to sit here and argue about the legal definition and what's a crime and what isn't. If somebody gets charged with perjury, that is a criminal felony charge. You have to go through the prosecuting attorney and the police. Okay? So that's what you are alleging.
Yes, the document will show that, and I've also sent forth.
No longer gently clarifying. He's correcting. Notice how he repeatedly says, no, that's not impatience. That's boundary setting. The court cannot operate on personal interpretations of legal definitions. If the foundation of your argument is flawed, everything built on top collapses. And here's what's really important. The judge is asking simple, structured questions. Was there testimony? Was there a sworn false statement? Those are objective requirements. Instead of answering directly, she shifts back to emotion and disagreement. That mismatch between legal structure and personal conviction is why this hearing is spiraling. Courtrooms reward clarity, not volume. And the gap between those two things is why
I emailed that.
Did you amend your complaint?
I didn't have to amend my complaint. I had to get an address for him. So I sent it to the second known address.
No. If you are alleging a different count, you've got to amend your complaint to add it in. You can't, I don't know what you said you did, but the last
time we spoke, the last time we were in court, I never changed anything. It's just that he was not properly served. So I had to get an address for him in order for him to be properly served. That's what was the last incident that transpired, was for me to get a correct address for him.
That has nothing to do with what I asked you about.
I know you asked me about an amended.
I asked you about what your claim is about. You said intentional infliction of harm, and I assume you mean intentional infliction of emotional distress. And you said perjury. That's the basis for your claim.
Yes, I'll amend the complaint. I thought I had that already in there. I received a document, I guess after I sent the correct address and he got the document, he sent a letter that should be, I guess, in the file. He sent a letter. And
that's
then
his answer, I guess. We're treating it as his answer.
Right. And so I emailed my response to that letter, because in that letter, he lied. And then that's what brought forth the perjury. It was never perjury.
Says, are we done here? To a judge, that's not confidence, that's combustion. Court is procedural. It's methodical. You don't control the pacing. The judge does. And what's happening now is subtle but critical. The judge realizes she believes disagreement equals criminal conduct. That's a dangerous misunderstanding. Filing multiple cases, threatening parallel actions, insisting on dual proceedings. That's not strategy. That's procedural chaos. And when she suggests she'll just file another case without dismissing this one, that shows a fundamental misunderstanding of how courts prevent duplicative litigation. Judges are patient, until patience turns into preservation of order. And we're getting very close.
Is in the answer.
I'm not saying he can't, but
you can't add another count because you don't like or you disagree with what is in his answer.
If he responds and his response is a lie, it's perjury, then my documents will prove that he lied in his response.
No.
Exactly. And I got documents that prove he was lying.
You don't understand. It's a false statement made under oath. Under oath.
That stated a
when did he testify to something that he lied about? It's a false statement made under oath.
Bottom line is, you said it's a criminal offense, so I will send it to circuit court. Done here. Are we done here?
Perjury is
I know
Perjury
exactly what
is
perjury
a
means.
false
I know exactly what
statement
perjury
made
means.
under
I know
oath.
what perjury means. Are we done
No,
here?
you
Is it a
don't.
criminal offense or not?
What statement? I don't see anything in the complaint that says he made some false statement under oath.
Because you don't know what happened. You're on the outside looking in. You don't know
But you're the
anything
plaintiff.
put on
You
that
have, wait a
document.
minute, you are the
Are we
plaintiff.
done here?
You have to
Are we
lay
done
out
here?
your
Are we done
allegations
here?
properly.
Are we done here?
No,
I
we're
know
not.
exactly what perjury means.
No, we're
Do
not.
insult my intelligence.
You have to
Please do not insult my
you have
intelligence.
to lay your, you have to lay your,
Please do
you
not
have to
insult my
lay
intelligence.
your complaint out. It has, you have to.
Important clarification of the entire hearing. The judge lays it out cleanly. Intentional infliction of emotional distress is civil. Circuit court handles civil matters too. The confusion was hers, not the court's. And this moment matters because it shows how assumptions can distort understanding. She believed circuit court meant criminal court. That belief shaped her argument. But courts are layered systems with divided authority. District court handles certain civil matters. Circuit court handles others. It's structural, not personal. The judge even repeats himself calmly. That's restraint. And here's the lesson. When you misunderstand jurisdiction, you're not just in the wrong room. You're arguing the wrong...
Insult my intelligence.
I said no.
Do not do that. Do not do that. Do not insult my intelligence as if I do not understand what the word perjury means. Do not. If it's a criminal offense, then it's a criminal offense.
Well, ma'am, it should not have been filed in district court if you want intentional infliction of emotional distress.
Okay, so that's a criminal offense.
Do you want, are you going to dismiss it and refile it?
No,
in
I'm
circuit?
not. No, I'm not going to dismiss it. I will file another case in circuit. But as far as I'm concerned,
you can't
no,
have two cases on the ma'am. You can't have two cases going on the same issue.
Well, I'm not. Well, I'm not dismissing the case. If you want to dismiss it, that's up to you. But I, as a plaintiff, am not dismissing the case.
He has to make a proper motion.
Well, that's on him.
But I can also transfer the venue to circuit.
Yes, that's what.
Like that, the ruling lands. The case is transferred to circuit court. Filing fees must be paid. And if she doesn't follow through within 56 days, it's dismissed. She has 21 days to appeal. What started as a $10,000 emotional distress claim over one date has now become a lesson in jurisdiction, procedure, and the consequences of doubling down without understanding the law. The judge remained measured, the defendant remained stunned, and the plaintiff remained convinced. Whether this case continues depends not on emotion, but on paperwork and payment. If you found this case as shocking as we did, hit that like button. Share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.
With appearing because you filed it in the wrong court.
I need to see because I was not aware, since you said perjury was not on there, I was not aware that a criminal offense for intentional infliction of emotional distress was considered a criminal offense there, that it had to be.
I didn't say that. That is not what I said.
Yes,
that is not what I said.
That is what you said.
That. No, I didn't.
Yes,
said
you did.
that.
You stated
I said that circuit.
You stated that the criminal. You stated that emotional infliction on the document that I placed forth before you. So criminal offense would not.
It's not in the complaint.
On there.
It's not in the complaint.
I need you to show me. I need you to show me the document which states that intentional infliction of emotional distress is indeed and in fact a criminal offense, because that's the original offense that was placed on there.
I never said that. I never said that.
Yes, you did.
I never said that.
Yes, you did.
No, I did not. Ma'am,
yes, you did.
Listen. I'm not going to sit here and go back and forth with you. I will repeat to you what I said.
I'm not either.
I said
so that's two
that
charges.
intentional. So you need to be quiet while I'm talking. You need to be quiet. Can you mute her, please?
Because perjury is a criminal offense. It has to go to circuit court.
That will not make her hear you.
Intentional.
Well, it is definitely a civil claim, but it is something that can't be done in district court. Now, that's what I said to you. You are of the mistaken belief that circuit court does not hear civil matters because you said, well, I thought circuit court only did criminal. You are the one who are mistaken about the jurisdiction of circuit court because that's what you stated on the record.
I can barely hear what you're saying. Like I said, I'm at the airport. There's a lot of people around.
Ma'am, are you getting ready to go on a trip or something?
No, I actually just came. I had a rental car.
Oh, I see. Okay. Ma'am, this is what I'm doing. I am ordering that this go to 7th Circuit Court. Venue is to be changed because intentional infliction of emotional distress is a circuit court matter outside the jurisdiction of district court. Plaintiff shall pay the filing fees in the receiving court.